How can a foreign registration make obtaining a U.S. registration easier? In a previous video, I discussed about the benefits of having a foreign registration, especially if it's a foreign registration in your home country. So meaning you're not a U.S. entity and you have a foreign registration and you have a registration of the country that is your home country. So if you're a UK entity and then you have a UK registration, a Canadian entity, you have a Canadian registration, there's a way to file into the US where you do not actually have to use your trademark in the US, because that is one of the requirements. The US is one of the few countries that in order to even get a registration in the US, you must have use in commerce. And what that means is that you're using that trademark on the product or services so that customers, clients know when they see that the source identified is your company. So that being said, if you're a foreign entity and have a foreign registration in your country, you can use that to get a trademark in the US. Of course, it still goes through a lot of the same examination that a US application would, meaning if there's another trademark in the US that was filed before you, that's going to block you under likelihood of confusion, assuming that the goods and services and the mark itself are similar. But if it's not, here's some things to know about using your foreign registration. Number one, that foreign registration has to be live. It has to be registered. It can't be that you had a foreign registration and now it is abandoned or canceled or you didn't pay the renewal, whatever it is. That registration has to be alive. The foreign registration must be enforced at the time the U.S. issues the registration based on that foreign registration. So that's number one. Number two is, what's important to know is the U.S. has really specific requirements as to the description of goods and services, whereas many foreign countries let you go much broader than what the U.S. will. In the U.S., in order to register a trademark, it has to be used on those goods and services that you listed. You can't list things that you are not using it on the registration, unless you are applying under this special section 44 where you can use your foreign registration. That being said, even in cases where the description of goods is just so broad that it's unacceptable to the US, they're going to require you to be more definite. And you see that here, the identification of goods and services in the US application must be definite and specific, even if the foreign registration includes overly broad identification. But the other thing to know about that is you can't add. So if you have a registration in a foreign country and then you apply in the US based on that under section 44, you can only get what you had in that foreign registration. You can't now add additional goods or services to that. And then, a third thing to know is that something you can do is you can use more than one foreign registration as a basis. So if you have multiple registrations that have different goods or different services, you can bring those all together into one application under the US, and each of those different goods or services would have to be relied on based on a foreign registration. And then one of the things that I didn't pull up the section for that here is you are going to need to show copies of those foreign registrations to the U.S. Patent and Trademark Office in order to support your claim for a foreign registration. If it's in a foreign language, you will need a translation of that. And I hope this helps for all you foreign countries out there that are looking to get into the U.S., looking to protect your rights here. This is one of the few benefits where it is easier as a foreign entity with a foreign registration to obtain a U.S. trademark registration. However, you will need to show use at a later date in order to maintain that registration. Use in the U.S., you have to show it between the 5th and 6th year, and then on every 10-year anniversary. Many foreign countries do not have that requirement. As I said at the beginning of the video, the U.S. is very specific in many of the requirements in the description and in how and in the fact that you have to use it in commerce in order to obtain a registration. When it's a Section 44 based on a foreign registration, you can get the registration first, but you are going to have to show at about the 5th year mark, unless someone attacks your trademark or you assert it against someone earlier, you may need to show that use in the US at an earlier date. Any questions, always feel free to reach out. Jason Rosenblum here, intellectual property attorney, protecting our clients' products, brands, and businesses from getting ripped off. Have a great day.